like to start off by introducing myself. My name is Mara Strazzieri. I'm the leader of the group, which means that I will be introducing my fellow group members and their areas of discussion, while also giving a summary of the case so you have a good understanding of what it's about before we go into more depth. Today you will also be hearing from Vivian who will be doing the Crown perspective, Jim Sidhu discussing the defense perspective, Miriam Calderon will be reviewing the court's decision and rationale, and Jasmine Permal will be examining the comparison to other cases. Behind the scenes, I would also like to give credit to Taylor Grossman and Avneet Sandal for doing the editing, bibliography, and discussion questions, and to Oriah Silver for the visuals and handout. So today we will be discussing the case of R.V. Morgenthaler, which took place on January 28th, 1988. In this case, we have the respondent, which is the Crown, meaning the Queen, and three appellants, whose names are Dr. Robert Scott, Dr. Leslie Frank Smalling, and of course the man that the case was named after, Dr. Henry Morgenthaler. The particular laws that this case looks at are Section 251 of the Criminal Code, which prohibits abortion except where the life or health of the woman are endangered. Also, whether or not abortion laws infringe upon Section 7 of the Canadian Charter of Rights and Freedoms, which is the right to life, liberty, and security of the person, and if so, if the infringement is justifiable. So the appellants mentioned above, which were all qualified medical practitioners, were charged for setting up a clinic to perform abortions on women who had not obtained a certificate from a therapeutic abortion committee of an accredited or approved hospital, which was required by Section 251 of the Criminal Code, in order to determine if the woman's life or health was at risk and if the abortion was actually necessary. These doctors made public statements questioning the abortion laws in Canada, claiming that a woman has a right to choose whether an abortion is appropriate for her individual circumstances, which I personally agree with. Indictments were preferred against the appellants, charging that they had conspired with each other with the intent to perform abortions regardless of the criminal code. The counsel for the appellants moved to drop the charges, arguing that Section 251 of the Criminal Code was ultra vires, meaning beyond one's legal power of authority, the Parliament of Canada, and that it infringes Section 2A, 7, and 12 of the Canadian Charter of Rights and Freedoms, and was inconsistent with Section 1B of the Canadian Bill of Rights. So just to review, Section 2A of the Canadian Charter of Rights and Freedoms is found under the Fundamental Freedom Rights and states that everyone has the freedom of conscience and religion. So due to their religion, some people believe that abortion is okay, while others believe that it was very wrong, but the choice to express these beliefs should be their own. Section 7, as mentioned before, states that everyone has the right to life, liberty, and security of the person. State interference with bodily integrity and serious state-imposed psychological stress, at least in the criminal law context, constitutes a breach of security of the person. A second breach of the right to security of the person occurs independently as a result of the delay in obtaining therapeutic abortions caused by the mandatory procedures of Section 251, which results in a higher probability of complications and greater risk. The harm to the psychological integrity of women seeking abortions was also clearly established. Section 12 of the Charter states that everyone has the right not to be subject to any cruel and unusual treatment or punishment, which in the case of abortion, the cruel and unusual punishment would be forcing these women to carry children that they don't want or can't take care of. You also never know what happened to cause the pregnancy. The woman could have been raped, and because of Section 251 of the Criminal Code stating that she can't have an abortion if her life or health wasn't at risk, those women are forced to carry around a reminder of such a horrible thing. In some cases, I guess women could fight this law, claiming that the pregnancy is just a reminder of the traumatic experience they had to endure and therefore has made them not want to live. in which case the life and mental health of the woman is endangered, and an abortion would be allowed under Section 251 of the Criminal Code. And lastly, Section 1B of the Canadian Bill of Rights ensures the right of the individual to equality before the law and the protection of the law. Some of the major problems with the abortion law in question is that one of the basic principles of our criminal justice system is that when Parliament creates a defense to a criminal charge, the defense should not be non-existent or so difficult to attain as to be practically non-existent. Section 251 actually fails to comply with these principles of fundamental justice, since the procedure and restrictions required for access to therapeutic abortions make the defense non-existent. Section 251 states that a therapeutic abortion may be approved by a therapeutic abortion committee of an accredited or approved hospital. This requires that at least 4 physicians be available at the hospital to authorize and to perform an abortion in practice, which makes abortions unavailable in many hospitals. Also, the restrictions attaching to the term accredited automatically disqualifies and restricts many Canadian hospitals from performing therapeutic abortions, and even if a hospital is eligible to create a therapeutic abortion committee, there's no requirement in Section 251 that states that the hospital has to do so. The word health is also very vague, and no adequate guidelines have been established for therapeutic abortion committees, so it's usually impossible for women to know in advance what standards of health will be applied by any given committee. It is because of these problems that the appellants set up their clinic to perform abortions, regardless of whether or not the woman had a certificate from an approved therapeutic abortion committee. I will now pass it on to my fellow group members to go into more details.
Moving to the Crown perspective in the R.V. Morgan-Taylor case. In the R.V. Morgan-Taylor case, the Crown filed for a cross appeal related to the issues already raised in the first appeal. As we know, in our first appeal, our appellants Dr. Henry Morgan-Taylor, Dr. Leslie Frank Smolin, and Dr. Robert Scott was acquitted. Specifically, in this case, there are concerns about Section 251 of the Criminal Code, which was basically the abortion law, and that was struck down on January 28, 1988. Section 251 of the Criminal Code limited pregnant women's access to abortions. It raised questions such as, does this infringe on women's equality rights, abridge freedom and religion, or inflict cruel and unusual punishment? The security of a person is brought into question now due to the psychological injury that may be caused in the delay of trying to obtain an abortion. But the Crown argued that any evidence of psychological injury is what could have been termed as administrative inefficiency. This means, for the purpose of Section 7 of the Charter, which protects the life, liberty, and security of a person, the relevance is put onto organizations instead of the actual evaluation of the legislation. The Crown argued that only the evidence that's related to the actual purpose of the legislation is relevant. The Crown argued that any assumption to the impairment of the physical or psychological interest of an individual caused by Section 251 of the Charter doesn't amount to the infringement of the security of a person. The reasoning they had behind this was due to the fact that the injury caused by practical difficulties was not intended by the legislator. Now we're going to look at Section 251 of the Criminal Code, Section 4, and the problems that arise with it. So this section states that the interest of the life and health of the pregnant woman takes precedence over the interest of prohibiting abortions. They had these therapeutic abortion committees that were comprised with no less than 3 members, all of which who were qualified medical practitioners that were appointed by the board of that hospital. So the purpose of that committee was to determine questions relating to the termination of pregnancy within that hospital. Some of the questions asked would be if the continuation of the pregnancy would be a danger to the life and health of the pregnant woman. What the Crown saw was that health was not defined for the purpose of this section, and medical professionals testified that the health standard in this case was ambiguous. As medical witnesses approve the World Health Organization's definition of health as being broad, it brings emphasis on the ambiguous language and how we can make sense of it. Though the courts weren't called upon in this appeal to evaluate the claims of fetal rights, the Crown does seek to protect the life and health of a pregnant woman, but also the interests of a fetus. Crown did cite precedents that indicate that the danger to the life or the health of a pregnant woman takes precedence over the interests of the fetus. Overall, the Crown believes that statutory control may be appropriate in determining the actual intent of Section 251, as women's rights do become more complicated when she becomes pregnant.
Before reaching a decision for the case R.B. Morgan-Taylor, the court declared the next 7 constitutional questions. So, the first question was, does Section 251 of the Criminal Code of Canada infringe or deny the rights and freedoms guaranteed by Section 2A, 7, 12, 15, 27, and 20 of the Canadian Charters of Rights and Freedoms? The question number 2, if Section 251 of the Criminal Code infringe or denies the rights and freedoms guaranteed by Section 2A, 7, 12, 15, 27, and 20 of the Charter, is Section 251 justified by Section 1 of the Canadian Charter of Rights and Freedoms, and therefore not inconsistent with the Constitution Act 1982? The question number 3, is Section 251 of the Criminal Code of Canada ultra-vires the Parliament of Canada? Then question number 4, does Section 251 of the Criminal Code of Canada violate Section 96 of the Constitution Act 1867? Question number 5, does Section 251 of the Criminal Code of Canada unlawfully delegate federal criminal power to provincial minister of health or therapeutic abortion committees, and in doing so, has the federal government abdicated its authority in this area? Question number 6, do sections 605, 610 of the Criminal Code infringe or deny the rights and freedoms guaranteed by Section 7, 11D, 11F, 11H, and 24 of the Canadian Charters of Rights and Freedoms? And the last question, if Sections 605 and 610 of the Criminal Code of Canada infringe or deny the rights and freedoms guaranteed by Section 7, 11D, 11F, 11H, and 24 of the Charter, are Sections 605 and 610 justified by Section 1 of the Charter, and therefore not inconsistent with the Constitution Act 1982? So, finally, the decision of R.B. Morgan-Taylor states that the appeal should be allowed and the acquittals restored. As part of this decision were the answers for the constitutional questions. So for the first question, the answer should be affirmative as regards Section 7, and the second in negative as regards Section 7. The third, fourth, and fifth questions should be answered in negative. The sixth constitutional question should be answered as well in negative with respect to Section 605 to the Criminal Code, of the Criminal Code, and should not be answered as regards Section 610. And the last question should not be answered. Section 7 of the Charter requires that the courts review the substance of legislation once the legislation has been determined to infringe an individual's right. Section 251 of the Criminal Code, which limits the pregnant woman's access to abortion, violates her right to life, liberty, and security, the meaning of the Section 7 of the Charter, in a way which does not accord with the principle of fundamental justice. This decision was formed by 3 series of reasoning. So the first one was initiated by Chief Justice Dixon and Justice Lammer. Their statement was based on the infringement of the right secured the person, which is the Section 7 of the Charter. Section 251 of the Criminal Code clearly interferes with a woman's physical and bodily integrity, forcing a woman by threat of criminal sanction to carry a fetus unless she met certain criteria unrelated to her own priorities and aspirations is a profound interference with a woman's body and thus an infringement to security of the person. A second breach of the right to security of the person occurs as a result of the delay in obtaining therapeutic abortions caused by the mandatory procedures of Section 251, which results in a higher probability of complication and greater risk. The harm to the psychological integrity of women seeking abortion was also clearly established. The second series of reasoning was given by Justice Betts and Justice St. The primary objective of Section 251 of the Criminal Code is the protection of the fetus. The protection of the life and health of the pregnant woman is an ancillary objective. The primary objective does relate to concerns which are pressing and substantial in a free and democratic society, and which, pursuant to the Section 1 of the Charter, justify reasonable limits to be put on a woman's right. Rules contained in Section 251 cannot be said to be rational connected to this objective. Under Section 1 of the Charter, are not reasonable and demonstrably justified. Consequently, Section 251 of the Criminal Code of Canada does not constitute a reasonable limit to the security of the person. Finally, the third series of reason was proposed by Madam Justice Wilson. Justice Wilson was the only judge in this case that believed that a woman not only has the right, but a charter right to have an abortion. She based this on the acknowledgement of the right to liberty, exclusively in the commencement of the gestation. The right to liberty contained in Section 7 of the Charter guaranteed to every individual a degree of personal autonomy over important decisions intimately affecting his or her private life. Justice Wilson was also the only judge that believed that the abortion law breached the Section 2A of the Charter, which includes the right to freedoms of conscience. Section 251 of the Criminal Code takes away the personal and private decision from the woman and gives it to a committee, which bases its decision on criteria entirely unrelated to the pregnant woman's priorities and aspirations. The deprivation of the Section 7 right in this case offends freedoms of conscience guaranteed in Section 2A of the Charter. This decision, whether or not to determine a pregnancy, is essentially a moral decision. And finally, despite the final decision to abolish the Canadian abortion law, what many people fail to understand is that the Supreme Court of Canada did not acknowledge a legal right to abortion. Also, the court failed to resolve this matter as is generally intended or demanded. Instead, the Supreme Court of Canada decided to hand over to Parliament the responsibility of creating and putting into place a new law concerning abortion. It had been appropriately passed by Parliament as opposed to by a provincial legislature. Justice Wilson was also the only judge that believed that the abortion law breached the Section 2A of the Charter, which includes the right to freedoms of conscience. Section 251 of the Criminal Code takes away the personal and private decision from the woman and gives it to a committee, which bases its decision on criteria entirely unrelated to the pregnant woman's priorities and aspirations. The deprivation of the Section 7 right in this case offends freedoms of conscience guaranteed in Section 2A of the Charter. This decision, whether or not to determine a pregnancy, is essentially a moral decision. Despite the final decision to abolish the Canadian abortion law, what many people fail to understand is that the Supreme Court of Canada did not acknowledge a legal right to abortion. Also, the court failed to resolve this matter as is generally intended or demanded. Instead, the Supreme Court of Canada decided to hand over to the Parliament the responsibility of creating and putting in place a new law concerning abortion. It had been appropriately passed by Parliament as opposed to by a provincial legislature.
Hi, my name is Jasmine, and I will be comparing the case of R versus Morgensler to the abortion trial of Emily Stowe. So first off, a little background history of abortion in Canada before the year 1988. Canada's criminal code required women who wished to have an abortion to seek approval from a therapeutic abortion committee of an approved hospital. Inducing abortion was a crime in Canada under Section 251 of the Criminal Code. The maximum penalty for a doctor or anyone else assisting a woman to end her pregnancy was life imprisonment. However, if the woman herself was convicted, it was a 2-year penalty. The Criminal Code was amended in 1969 by the government of Prime Minister Pierre Trudeau. It allowed doctors to perform abortions in accredited hospitals if a pregnancy threatened the life or health of a woman. However, a committee of doctors was required to approve the procedure. In all other circumstances, abortion remained illegal. R versus Morgensler. 3 doctors, Dr. Morgensler, Dr. Smalling, and Dr. Scott, set up a clinic to perform abortions for women who did not have the necessary approval, and the doctors were criminally charged since this was considered illegal. The Supreme Court held that Section 7 of the Canadian Charter of Rights and Freedoms was violated. This section states that everyone has the right to life, liberty, and security of the person and the right not to be deprived thereof except in accordance with the principles of fundamental justice. In this case, the life, liberty, and security went beyond the required protection of the physical health of the mother. The majority of the court found that the criminal code's restrictions on abortion were contrary to the charter. They held that a woman's inability to control the termination of a pregnancy constituted an unjustifiable loss of life, liberty, and security of the person. The Supreme Court of Canada struck down Canada's abortion law and decided that the Criminal Code restrictions on abortion were unconstitutional because they increased health risks to women, depriving them of the right to security of the person. This decision has led to giving women the freedom of choice. Since this case, Canada has not had a law prohibiting any type of abortions. Abortions have been legal at any stage in a woman's pregnancy and are publicly funded as a medical procedure under the Canadian Health Act. A case that is similar to R versus Morgensler is the abortion trial of Emily Stowe. This abortion case took place in 1879. Emily Stowe was the first woman in Ontario licensed to practice medicine, and she was the founder of the Canadian Women's Suffrage Association. Stowe attended the Toronto School of Medicine but did not end up receiving her medical license. There was no record that she took the licensing exam required by the College of Physicians and Surgeons of Ontario. Stowe continued to practice medicine without a medical license for over a decade. In 1879, she was involved in a criminal act. Stowe was charged with performing an abortion on one of her patients, 19-year-old Sarah Lavelle, who died mysteriously. Stowe was accused of trying to help Lavelle have an abortion, which was illegal at the time. Stowe testified that she had given Lavelle a drug that could cause a miscarriage, but she only gave her 1/30th of the full dose. The given dosage was too small to cause a miscarriage. When Stowe testified, she proved herself to be a knowledgeable and skilled medical practitioner. The coroner's jury determined that Lavelle had poisoned herself. Stowe was charged with the criminal act of administering drugs to cause an abortion. After the trial, Stowe was acquitted and gained fame and public support during the trial. The prosecution of Stowe demonstrated how seriously authorities viewed the crime of abortion in the first decades following Confederation. The case of Emily Stowe and Morgensler are similar because they both involved illegal abortions, and both people were acquitted of the crime.
We believe that any woman should have the right to ask for a termination of pregnancy within the first 3 months of pregnancy, because we believe that she alone should make the responsible decision whether she wants this pregnancy to continue or not.
Henry Morgentaler emerged as a public advocate for abortion in October of 1967 when he testified before a government committee. Born in 1923 in Poland, the young Montreal doctor survived the Holocaust, spending time inside the concentration camps Auschwitz and Dachau. In other words, Henry Morgentaler was used to a fight, and in 1969 he got one when he began performing what would end up being thousands of illegal abortions.
Do you remember the first abortion that you performed when you decided to essentially cross the Rubicon?
Well, it was an 18-year-old girl who was brought to me by her mother. Everything went well. We had a good result, and she was happy, the mother was happy, I was happy, so.
Did you know in doing it that you were about to embark on something that would change your life?
I think that I knew that if I started doing abortions on a bigger scale, that eventually I'd have to face the criminal code and prosecution and things like that. But I was convinced in my mind that if I came before a jury and I explained my motivations, that I would be acquitted, and this is exactly what happened.
Morgentaler spent much of the 1970s fighting a series of criminal charges, and although he was never convicted by a jury, he did spend time in a Quebec prison after a court of appeal overturned a not guilty verdict. In the 1980s, he took his fight to the rest of Canada, mostly Ontario, and in 1983, he was charged in Ontario for procuring illegal miscarriages. That case ended up at the Supreme Court and resulted in the now famous decision Morgentaler versus the Queen. But now, at the age of 84, with his third wife, Arlene, beside him, Henry Morgentaler invited us into his home to speak candidly about the personal events that motivated his long struggle, from his life during World War II to the serious stroke he suffered from last year.
How close were you to death, Henry?
Quite close. I survived that, and I survived also an operation on my heart. So I'm sort of a newborn baby now, if you could say that. And I enjoy being alive.
Did you ever struggle philosophically with the abortion question? I mean, what would give us your...
Sure. I struggled with all this. I'm a thinking person. I came to the conclusion that here was a law and a practice that was based on wrong assumptions, mostly religious, and that it was time for somebody, and that was me, to raise this issue so that women would be protected against all the hazards of bad abortion, self-induced abortion, injury as a result of that.
But even though Henry Morgentaler won all these arguments in the Supreme Court, the battle on the ground has raged on. In 1992, his clinic in Toronto was bombed, and he and thousands of women who use his clinics have been subjected to years of threats and verbal abuse. And even today, access to abortion is far from guaranteed. The procedure is still not available in every province, and it remains expensive. Women in rural and northern communities have to travel hundreds of miles or more in order to obtain the procedure. For Morgentaler, the fight goes on.
What was the most frightening time for you?
You knew that any time somebody could just fire a bullet into me, and that was it, you know. So whenever I went to the clinic, and there were protesters, and they were not the kindest people in the world, you know, they're shouting slogans and vilifying me and threatening me. Well, it took me a while, and a few minutes, at least 15 minutes, to calm down and be able to do my work, because it had an effect.
Were you prepared to be killed for this cause?
Yeah, well, I was prepared, but I hoped it wouldn't happen. But I was prepared. I knew I was in a kind of dangerous profession. I knew that doctors were being shot. I knew that I was a target, And I was determined to be able to continue in spite of all that.
Morgenthaler often says that his life has been given in the service of women. And in a new documentary called Henry, he explores that question in a very personal way, revealing his complicated series of marriages and affairs and the cost they had on his life. What do you think explains this, your relationships to women, the 3 marriages and sometimes a wife and sometimes another person?
Well, what explains it is my inordinate need to be loved by women. And sometime along my emotional development, I got the impression that my mother didn't love me because there was a younger baby that she devoted a lot of attention to, which happens in many families, I guess. I personally believed that she neglected me and she didn't love me. So to be loved by women was emotionally to me very important.
Many people described you as a womanizer. Would you think that's fair?
Well, I think it's reasonably fair, yes. I like women, and there's no reason why I should apologize for that.
Do you think that you had one of the drivers for your life was an ego, a need to be the center of attention?
Yeah, probably, yes. Being the center of attention validates you. It means I'm important. I do important things. I can be recognized for that. And yeah, that was like a leitmotif in most of my life.
Egoist, crusader, hero. 20 years after the Supreme Court decision that changed so many lives, Henry Morgenthaler remains one of the most controversial and complicated figures in Canadian history. And as if recognizing this, at the end of our interview, Morgenthaler gave me a book of poems that he's just put together in which he explores his inner life and perhaps gives an insight into just who he really is. This poem is called The Goddess of the Golden Breast.
My God is a goddess with golden breasts, dripping milk and honey. A suckling baby am I, nursing at the golden breasts. The whole world is one big breast, and I am the suckling. I lie in the Caribbean sun, and the pores of my skin suck in the rays of the sun. The sea is a sea of milk. The mountains are giant nipples. The earth is, in its splendor is the mother's body, producing milk for me. Sometimes I would like to devour the breast that is feeding me, to tear at the nipple and bite it, but could not stand losing it. It feels so good to suck and suck and suck. Sometimes I feel that the nipple drips poison that goes straight to my heart, and by the magic power keeps me from growing out of needing the breast. I spit and reject the poisoned milk. I hit and curse the breast and the mother. I smash the goddess to bits, and then I look at myself, helpless, small and hungry, and cry. And the mother goddess appears, her golden nipples full of milk and honey, and I suck again and drink again, and again I am a little suckling.